Hello, hello everyone. Hello.
Hi Vijay, I just sent you, I just accepted the request. I believe you should receive uh, by now. Please have a look. If not, I'll send another request. Hi Vijay.
Hi, how are you?
I'm I'm good. How are you?
I'm doing well, thanks.
Thank you for joining on a weekend. I really appreciate
It's
your time.
it's my pleasure.
Yes, sir. Yes, sir. So now, first of all, welcome Vijay. Welcome to our live, and hello everybody. So we have Vijay here. Vijay Yellareddigari is the managing partner and attorney at Somiredi Law Group. He practices in litigation and corporate law and real estate a lot. He has major focus on real estate, especially, and he also have his bachelor's degree in accounts, and later on he worked for a mortgage company as a financial analyst, and then got his JD, worked in India in High Court, and I also believe Supreme Court, and then he is currently practicing in New Jersey, United States. And thanks for joining, Vijay. Probably I might miss some of some of the specialties or some of your intro. I would definitely like to hear from you.
Sure, thank you, Ravi. It's certainly a pleasure talking to all of you. I think you covered everything that I do, but
Really? Okay.
just to clarify, I did clerk for the Supreme Court of India in 2010, I believe, and also the High Court of Andhra Pradesh before the split happened between the two states.
Mhm.
And then here in the United States, I've practiced defending Fortune 500 companies to smaller companies. Now with Somerdy Law Group, we kind of help everyone, not just the big companies. We do individuals as well. And then I've also worked for the New Jersey Attorney General's office doing white collar prosecutions, as well as now I serve on the board of directors for my law school. And I also do a little bit of community service. I work for the Civil Air Patrol, U.S. Air Force as an attorney for them.
Awesome, awesome. That's a great portfolio, Vijay.
Thank you.
So, what made you to come into law?
It was one of those things. I was tired of being a financial analyst right during the mortgage crisis. So I saw all
Mhm.
the issues that happened in 2007, 2008, and I wanted something different. And
Understood.
both my parents were lawyers in India.
Oh,
So they actually told me not to do it. They wanted me to be a doctor, but I needed to go against what my parents said. So I ended up going into
oh,
law.
that's awesome. So, I think you're born and brought up here. Is
No,
it not
actually, I
wrong?
was born in Hyderabad,
Oh, really?
raised in Hyderabad. I grew up here. I think I was about 9 or 10 when I moved to the United States.
Oh, okay, okay, okay.
Yeah, so I
Oh,
could
that's great.
speak Telugu, I could speak Hindi. Yeah, I just can't read and write.
That's great to
Yeah,
know. And we have a community of a lot of non-immigrants, and many people have a lot of questions, and most people don't know how to handle them. Before we get started into any specific topic, I just want to ask you this question.
sure.
What is litigation? Can you give a brief?
So litigation is usually when two parties have a dispute and they try to resolve it. Litigation can be in many forms. It could be just arguing between two parties, right? Not the ideal form. You also have court litigation. So you actually go to trial, you go before a judge, you could bring your case, yeah, you defend your case, depends which side you're on. You have alternate dispute resolution, which is more popular these days, where you have mediation or arbitration, where you hear the entire matter before a mediator or arbitrator and have it resolved that way. Um, Nowadays, majority of the litigation still is typical judge and jury. You're starting to see some of the contracts lean towards ADR, which is alternate dispute resolution, either
Mhm.
through mediation or arbitration.
Understood.
If you need me to go in more detail, I can with either or.
Right, right, right. I know. In the last time when we spoke, you mentioned a lot of topics, and I want to make it more specific to at least two or three topics so that we can
Sure,
talk in detail. And in the next session, we can also talk about more stuff.
sure.
And also, I see someone's request. Can you speak a little slow so that everyone can
Okay,
understand?
no
Because you have
worries.
that thick American accent, so
Sure,
I want everyone to be comfortable
sure.
while listening. And the other thing is, many people don't know how to respond to uh, a notice, a legal notice. Some people ignore, some people respond to it, and some people don't know how to respond to it. What is the best way, and what should we do when someone receives a legal notice
Sure.
or summons? And summons, yeah.
Sure. So there's obviously two different type of legal notices, and I think you just brought that
Mm-hmm.
out, which is your typical attorney letter and
Mm-hmm.
then the summons.
Okay.
Attorney letters are informal. It's good idea to respond to them, and you can just call. They usually put a phone number or an email address on that letter.
Mm-hmm.
Reach out to them. I wouldn't disclose anything about your case, talk about your case. Just find out what they're looking for.
Okay.
The reason I say do that is because when an attorney sends out that letter before they file in court,
Mm-hmm.
you're able to save a lot of money if you're able to settle it then. Because once they file in court, they're going to want attorney's fees, court costs, all these extra things, which you can avoid if you try to resolve the matter beforehand. And sometimes attorneys are willing to settle it for pennies on the dollar if it's done before they file in court. So
Understood.
it's a good idea to respond to that, but it's not the end of the world if you don't.
Understood.
But yeah, I always say just talk to an attorney if you can hire one. If you can't hire one, at least talk to the attorney who sent the letter. Don't disclose anything about your case. That's anything you discuss with the attorney they can use against you in court. So be very careful what you say at that stage.
Okay. Okay.
Now to the other part of your question, which is what if you receive legal summons? Now that's an official document from the court. You really should not ignore it, because if you ignore it, there could be many repercussions. Depends on what type of summons they are. If it's an initial filing, a pleading that's been filed in court against you, there could be a default against you. A default judgment basically is the court saying, hey, the other side did not respond, so plaintiff, we're giving you whatever you're asking for. So if the plaintiff has a case and they say, we're suing you for $50,000 and you don't show up or you don't respond, they potentially could get the $50,000 plus attorney's fees as a judgment against you.
Okay.
Where you may have a chance to fight it, maybe it's only the case may be only worth $5,000. But if you don't show up, they can get the full amount that they're asking for.
Understood. Yeah. Understood. But good to know.
Yeah. And one thing I do want to say, whatever advice I'm giving here is technically not legal advice for any specific individual. It's general legal discussion, and each jurisdiction has their own rules. Unfortunately, in the litigation world, every jurisdiction, when I say jurisdiction, every state has their own laws, own procedures. So it can vary from jurisdiction to jurisdiction. You really should talk to an attorney in that jurisdiction to better assist you.
Understood. Thanks for giving the disclaimer.
Sure.
Yeah. And another basic question. Let's say I have an argument with someone. I want to send a legal notice. What is the procedure and how expensive it is to send the first legal notice?
Yeah. So, legal notice, it's been kind of said many times, and people assume it's a very formal document. It's really a communication letting the other side know, hey, there is a disagreement between the parties here. I'm demanding this, and I need this to be done. Do you need a lawyer to send that? Not really. You could send it yourself, but when there's a lawyer involved, people take it seriously. As far as cost, it's probably the least expensive thing you could do. And like I said earlier, if you settle at that point, you're not spending much at all, right? You can potentially have a $50,000, $100,000 claim settled by a few $100s by sending a legal notice. So it's not very expensive. Really depends on what's involved. It'd just be a few $100s.
Understood. Understood. So a few $100. I think anyone can do that, I guess.
Yes.
Depending upon any kind of case. Any
Correct.
kind of disagreement, any kind of argument.
Yeah.
Okay. So if someone wants to reach out to you, so does the same email works? info@somireadylaw.com?
info@somireadylaw.com works, or litigation@somireadylaw.com works as well.
Litigation at somireadylaw.com.
Either or would work. It'll come to our team. We'll respond to you, and depends on what type of matter, the appropriate attorney or team member will be assigned.
Perfect. The hot topic is employment.
Yes.
But before we get into that, there are a lot of reckless drivers in our community who do not hold an insurance policy and drive and get into accidents. So I would like to address this topic first.
Yeah.
What happens if you drive a car without an insurance policy and involved in an accident?
So a couple of things can happen. It depends on your jurisdiction. If your jurisdiction requires insurance coverage, and each jurisdiction has minimum coverage requirements, some don't have any. So if your jurisdiction requires insurance coverage and you don't, or a minimum insurance coverage, and you don't have it and you get in an accident, most likely the police will show up. Either party will call the police. When the police come, they ask for the documentation. You're going to get multiple tickets from the police for potentially the reckless driving itself, potentially for not having insurance. You could have lots of points. You can have suspension, depends on the jurisdiction. Additionally, the bigger issue is going to be if you cause injuries or damage, right, to the other party.
Yeah.
If you don't have insurance, you're on the hook for all of that, right? They can sue you personally. And when they sue you personally, let's say you get in a car accident and nothing crazy, but let's say you just hit them really hard from the rear, right? They were stopped at a traffic light, you come in really fast, you forget to hit the brakes or you're going too fast. You collide. Probably they're not hurt too bad right now. They say, oh, I'm fine. Few months later, the neck pains, the back pains start coming in. And these kinds of things don't show up immediately because you're in shock. Your body is still trying to figure out what happened. So these issues don't come up immediately. Not the same day, not the same week, not the same month. It'll happen a few months later. They're going to go to a doctor. The doctor's going to say, hey, you have a herniated disc or you have a neck injury or whatever. Then they're going to go see a lawyer. Personal injury lawyers, they're there, and you've seen billboards everywhere. You've seen the flyers. You get injured, call 1-800-so-and-so. The purpose they're there, and they collect on a contingency basis. So the person filing that claim, they're not paying anything. So what happens is they're going to file for a simple neck injury, $200,000-$300,000 claim, maybe even $1 million claim, right? If you don't have insurance, that's all going to fall on you. And if you own a house, you own a car, you own anything, your bank accounts, your 401ks, they can take all of that.
Oh my God.
So it's a good idea to have insurance, one, and two, be careful driving.
Yeah. I would say first thing will be careful driving.
Yes.
And definitely you should have insurance.
Yes.
Okay. So how to protect personal assets? Let's say even though if I have insurance policy and my coverage is only $25,000 for the other party, do they have any possibility the other party can come on to my personal assets?
So if their claim amount exceeds your policy amount, so they're saying their injuries are $500,000 and your policy is, let's say, $50,000, right? So they certainly have $450,000 that they can come after you for. In that scenario, if they win in court for the full $500,000, your insurance will pay out $50,000. Anything more will be your responsibility. So one way you can protect is you can add on what's called, there's different insurance policies out there. Umbrella policies are something you can do to protect yourself. But what I always say, first things first, if you ever get in an accident, one, make sure everybody's safe and unharmed. After that, document everything. Document, because the attorney you're going to hire to represent you, whether your insurance carrier hires an attorney for you or you have to hire your own attorney, the documentation helps big time.
Understood. And we also see a lot of things that while during the accident nothing happens, the other party will be super good, but later on, once they find out we have a good insurance policy, they come behind us.
Yes.
So how to protect in those cases? Are there any ways?
There are. First things first, anytime, even if it's the smallest of collision, even if it's a tiny fender bender, right? There's a small scratch on them. Get a police report. I know it's going to take time out of your day for the police to show up and do all that. Get a police report, document by video and pictures. So all my vehicles have dash cams. I suggest installing those. There's a lot of insurance fraud out there. Having a dash cam helps on multiple counts, and not only for the accidents, but some of these dash cams now have speeds. They keep track of speed. If you get pulled over by the police, we do traffic violations as well. Speeding, you could say, hey, I have dash cam evidence that shows I'm doing 55 and a 65, not what the police might say you did. So that way it'll help too. But document by video, photos, and if they're going to say, hey, I'm not injured or anything, have them, if you can get it on video, that'd be great. and you get a police report. That is very important because a police report is going to be admissible in any court. Some of this video and photos may or may not be, depends on how you testify in court, but that police report will be easily admissible.
Understood.
Yeah.
And in some cases, some people do not file police complaint just because they mutually agree upon something, exchange their information, they go back to their work. And after that, someone can chase others.
Yeah.
So
And, sorry, go ahead.
how strong those cases will be?
They're just as strong because remember, it costs you money whether you're going to actually win or lose. You're going to pay for attorneys. It's going to cost you money. If you can make your case airtight from day one, you don't have to pay me, right? And attorneys aren't cheap,
right?
Generally.
Right.
So you want to save yourself and protect yourself. Get that police report. Even if they say, "Oh, it's a small thing," just get it. You'll be covered. You'll be protected. Now, if you decide not to go through insurance for, a small paint job on the car, that's between you and the other party. But if you think there's injuries or any claims like that, go through insurance just to protect yourself. Because if you don't, insurance may not cover you down the road.
Understood. So what do you suggest? Let's say even if we mutually agree and let's say I paid out of pocket $1,000, he went off and later on he filed with his insurance that this thing happened and this guy did like that, and he might claim like some 50,000, 100,000 charges for medical treatment. So how to deal in that case?
So in that scenario, if you're giving any money to anyone at any point in time, draw up a simple settlement agreement between the parties, a general release and settlement, saying, I would probably put something very simple. You can find them online. You can call our office. We'll be happy to draft one for you. It won't cost you much. A settlement agreement that says, hey, this accident occurred on this date and this time. Both parties acknowledge there were no injuries at the time of the accident. Let's say I'm the person who caused the accident. I would write in, Vijay Yellareddigari has caused this accident, or I wouldn't even maybe admit, I might just say, this accident has been resolved. There's some damage to the cars, and I'm paying $1,000 to the other side, and they're acknowledging that 1,000, and both parties release any claims after that. Now, that may protect you to an extent, because the other side, once they see that they've released, they may not even think about if there's small things later to go to an attorney, because they're like, oh, I gave up my rights.
Right.
If there are actual physical injuries that manifest after that settlement, they could potentially legally still go, but this at least deters them from fraudulent claims.
Exactly.
Yeah.
Got it. Does let's say I don't have that legal settlement template. Can I exchange that information, or can I send that information in the form of email and get acknowledgement from the other party?
If possible, I would have them at least handwrite a document saying we both agree. Both agree, or type up the document and sign it. Because because emails, they may dispute, I didn't answer to that email, or someone else used the email. That's not my email address. So it's easier if it's signed.
Understood.
Yeah.
Perfect. And let's say if I receive a legal notice after 1 year, most insurance companies settle them. But if they come for any additional demands, how can I deal? Is there any way that I can protect myself without getting any legal notices or without getting sued?
Well, that's an age-old question. I wish I had a definite answer. We are a litigious society. We take steps to protect ourselves to limit that exposure, but there's no way you can protect yourself 100% from ever being sued.
Understood.
So even if you have settlement agreements, even if the money's been paid out, they'll file a suit. You could probably get it dismissed. A good attorney probably will get it dismissed very quickly because there's no real case there, but we can't prevent the lawsuit from ever being filed.
Understood.
Now, certain settlement agreements, when we settle, especially if you give a large sum, we may put certain clauses in that settlement agreement that say that, hey, you can't sue. If you sue, because we've already addressed this matter, you owe me money. We can put language like that, but we can't prevent them from actually taking that action.
Understood. Okay, perfect. Yeah. And do you have any scenarios that you want to share with us with respect to accident lawsuits?
Yeah, a few.
Yeah.
So I'm trying to think. common thing that happens, right? We get into an accident, especially on the injury side. We haven't talked about from the
Right.
injury side. What if
Right.
you're the one that's been hit, right? First things first, what I tell clients, and this comes in handy because I did it on the personal injury side as well, when I worked on that side. First, get the police report, and then once the police report is done, go about your things. If you feel any pain, even if you think it's just a sore neck or sore muscle, whatever, go seek immediate medical attention. You can go, if it's really painful, go to the emergency room. If it's not very painful, go to your normal primary care physician. Document it, because then they'll document it. That's a report that's there saying, hey, this person has been injured during this motor vehicle incident. Maybe nothing comes out of it, maybe something comes out of it.
Right.
Because like I said, most of the time these pains don't come immediately. It'll come a few months, few weeks later. And so when these actually come out, I've had, I'm going back a few years now, I had a client, got in an accident, nothing crazy, just someone hit from rear. They just felt a slight amount of pain. They went about their life normally, no problems. 2-3 years later, pains got really bad. They couldn't even pick up their grandchild because they just couldn't lift their shoulder because the pain was so bad. Went in, and then the surgeon said, have you had any trauma back there? And they couldn't remember. After a while, they remembered that they had an accident, they had a whiplash situation. Really, at that point, there's still, so a lot of jurisdictions allow the 2 or 4 years, depends on where you are, statute of limitations. So statute of limitations is when there's a limit on how long you have to bring the case.
Okay.
Most jurisdictions have anywhere from 2 to 6 years for personal injury claims, but some jurisdictions say it's from the moment you discover the injury, not from when the incident occurred. So you may still have that option to go after them, but that's not necessarily something that would happen always, right? So in that scenario, we were able to figure out, go back through insurance records and see what accident. We did file a claim, and then the insurance carrier ended up settling. I think it was a few $100,000 for that neck injury.
So, however, we should always protect ourselves with at least an insurance policy first.
Correct. And then seek medical attention. More than anything, even whether you file in court or not, seek medical attention. If it's minor, take care of it, be done with it. If it ends up being major, then we can potentially file in court.
Perfect. Thank you, Vijay.
Sure.
I think we can jump on to employment now.
Sure.
And nowadays, you might heard a lot of cases, especially employers not paying employees dues, like 3 months, 6 months, and they are not getting proper responses when they are following up. What is the best way for them to get back their money? So what do you suggest here?
So I think there's going to be a common theme of everything we discussed today. The first word I'm going to say is document. Right? The reason I say that is, as an attorney, as a litigation attorney that goes to trials, the more evidence we have that's in physical document, when I say physical document, email or text message, anything, as long as it's documented, not just verbal, right? If you can document it, that's going to come 100-fold in your favor when we go to trial, if we have to go to trial. Even if we don't go to trial, if I'm filing a demand notice or just a complaint in court, the more documentation you have, the other side's going to back down very quickly. As far as what do you do to protect, right, from an employer not paying you? First and foremost, any agreements you have with an employer, have it in writing. Because whether you file a Department of Labor claim or you file in court using an attorney, the more evidence you have, again, written, documented evidence, that's why an employment agreement comes in handy. Because if you have an employment agreement, you'll know what your wages are. You'll know whether you're an exempt or non-exempt employee, right, for overtime and all of those things. So this way, you'll have that proof. You don't have to testify. You could just show that employment agreement, and that's enough. They don't need any more evidence in that support. So have an employment agreement in place, 1. 2, as soon as the first payment is missed, because if they miss one payment, likelihood they're going to miss many payments. First payment is missed, follow up. Follow up immediately in writing, not verbal. Get it right, response in writing, what they're going to do. In most jurisdictions, the Department of Labor, and I'm not talking about U.S. Department of Labor. I'm talking about the statewide Department of Labor. And some states don't have it, or they don't get involved in these sort of claims. They have some sort of division. For example, in New Jersey, we have a wage and hour division. That division is responsible for prosecuting any claims of employees that have not been paid. And what employees forget is you don't have to wait 6 months or 5 months or 3 months. You can file it immediately. Even if they miss by a day, there's penalties for the employer. So you don't have to give them months and months. The longer it takes, the harder it is to collect. Because if it's one paycheck, and I'm just gonna go with an employee who's making like, 100,000, probably $4,000 or $5,000 paycheck. Easier to get them to pay. If it piles up to 5 months, that's $50,000. It's harder to get them to pay it.
Right.
So jump on it immediately. And then either you follow up or file with the Department of Labor, because Department of Labor, once you file in most jurisdictions, they're just so backed up because the states don't have the funding. It'll take a few months. Once you file it, if you file in January, you're probably not going to have a hearing till October or November. So it takes about 7-8 months in most jurisdictions. If you want to hire an attorney, like our firm does a lot of these claims, reach out to an attorney. We'll send a demand letter out immediately. It'll curb that behavior by the employer immediately. So that's what I would suggest to kind of limit your liability.
Understood. How does the fee structure works? Because I heard from your firm that you generally don't charge upfront fees. You take the percentage from the money that you recover. Is that right? How does it work?
It depends on the type of claim it is. So we have 3 different type of fee structures. We have a flat fee where we just charge one fee and that covers everything. You don't have to worry about any more or any less. Then we have a contingency, which is what you were talking about, where we say, if we win this case, we'll collect a certain percentage. Whatever that amount might be, we'll get a percentage off of that. We'll agree to that percentage ahead of time, and we'll just take that. And then the last is going to be an hourly. Hourly, we just build based on the amount of work that an attorney or the staff put in on your case. So it really depends on the type of matter and what's involved. We may do different structures. And what you have to also understand, sometimes in some jurisdictions, any Department of Labor violations can also have attorney's fees. So the employer has to pay your attorney's fees. So that's why contact an attorney. You may never have to pay them because the other side might have to pay. Only time that doesn't work is if there's a settlement. If there's a settlement, the other side's not going to pay your attorney's fees. So contact our firm. We'll talk to you. We'll let you know what, based on your circumstances, what would be the fee structure.
So from employee side, we were talking until now. Are there any parameters employer can stop the payment to employee legally?
Yes and no. Very few parameters. So if the employee has borrowed money from the employer in advance, they can do that. If there's a judgment against the employee, and the court has issued a garnishment order, then the employer can withhold that money to send it to whoever that. Now, remember, we talked about the insurance side. You get sued and you lose money. If you don't have a house, you don't have a car, they can still go after your wages through a garnishment order. So if you make, let's say, $5,000 a month, the court can say, you don't need the $5,000 a month because you owe these people $100,000. We're going to take $2,000 or $2,500 from your paycheck every month, and the employer will withhold it. So the money that doesn't even get to your bank, it's withheld before it even gets to you from the employer. So that's another reason that the employer can withhold. If there's any other court orders, or if there's any agreements between you and the employer ahead of time that this money can be withheld. Those are generally the reasons why an employer, and each jurisdiction, again, has different requirements on that, but generally, nationwide, that probably kind of holds true.
Understood. And when we look from employer side, most employers try to file or raise a petition in the form of non-compete. There will be a lot of non-competes, and just because employee got hired by a vendor or employee got hired by actual client, employer will always have that right to stop, right?
Yes.
So can we talk a little bit about that?
Sure. Non-compete provisions, it's a big hot topic right now because there was an FTC regulation
Right.
earlier this year, which was supposed to go into effect from September, that said non-compete clauses are null and void in employment agreements. There has been some pushback on that. So jurisdictions are trying to grapple with how they're going to enforce that law. California, you won't be able to enforce that. Other jurisdictions, Texas, for example, they got overturned in court. So they will be able to enforce that provision. Other jurisdictions are still grappling. We actually have pending litigation in New Jersey with that. So we'll know hopefully soon how courts are going to rule one way or another on that. Before that regulation came out, generally speaking, Supreme Court ruling from the US Supreme Court was that if there are any covenants or restrictions like that, they have to be limited based on the scope. So they can't just say you can't just go work anywhere. Right? They have to say if you are a very specific area, for example, I'm a lawyer, right? And I do litigation. My employer can say any litigation within a 50-mile radius of this office, you cannot conduct it, right? Because they're limiting the scope and limiting the radius around, right? Geographic radius and time. They can't say forever. 1 year reasonable, depends on how much time and money they put into you as an employee and your expertise. They can maybe go to 2 years, 2.5 years, but anything more than that would be considered unreasonable and unenforceable. So if your employer says you can't ever work in this area or in this state or in this particular thing, that might be something that we can fight and get thrown out.
Understood. And can you give me some examples for non-compete? Is it only for employment? Let's say employee. Yeah, you go.
Sure. Non-competes can be not just employee-employer relationship. It can also be business scenarios, right? Correct. So most commonly it's used if you're selling your business, right? I own a business. I'm selling this business to a new buyer. That new buyer might not want you to sell the business to them and then go start up a new business next door, right? So a lot of times there'll be a time limit, and a lot of times there'll be a geographic distance. So I see this a lot. I have doctors' offices that we've done business transactions. We've done franchises. We've done restaurants. The owner sells it, then wants to go open another one 10 minutes down the road, right? That you don't want as a new buyer, you don't want it. So they put restriction on that, usually like 100-mile radius and 5 years or something like that.
Understood. And sometimes when employee leave a firm, especially we see in a lot of Indian consulting firms, when an employee leave a firm, along with holding a lot of dues, they also send some notices like you have to pay this much money for the trainings that we provided, for the amount that we spent on you. So how strong these cases can withstand, and does the employee really need to respond to that, or what is the best thing he have to do?
Well, so we'd have to look at their employment agreement. A lot of times they have liquidated damages provision. If that's there, then it potentially could be enforceable. What a liquidated damages provision is, when you sign that agreement, the employer and the employee are agreeing together, saying that, hey, if either party breaches, usually it's the employee breaching. If the employee breaches this contract, when I say breach, you're not following any of the requirements of the contract. If you breach the contract, we don't know what the actual damages will be a year from now, 2 years from now. So we're going to agree today, because we can't come up with a number then, to a number today. Usually it's 25,000 or 50,000. That's what the liquidated damages provisions are. So you'll agree and agree that it's not punitive. Punitive meaning it's not a punishment. It's just that we can't agree what those damages are. So we're just going to put a number today. So both parties can be prepared for that in the future. If those provisions are there, it's very difficult to fight them. I'm not saying it's impossible. We've fought them and won, but it can be difficult. The other provisions, if there are no liquidated damages provision, there could be a scenario where they can say, if you leave the employment within a year, we're going to charge you penalties. But they also in the contract they also say it's at will. Well, you got to have one or the other. You can't charge both.
Right.
So that's how we fight it, saying, hey, you're saying it's at will, you're saying there's a penalty for leaving, so we might be able to. And again, I say might because there's a lot of factors into it. Like if they spent a lot of time and effort on training and you didn't actually work for them at all, you just received all this training and you're leaving, might not be able to. Versus, you did provide multiple years of billing that they made money, then, I think we'll be able to fight that.
Understood. So right now we spoke about from employee's perspective. Let's talk from employer's perspective.
Sure.
Let's say I hired someone, I spent a lot of money on his wages, on his training. Let's say he stayed with us only for 3 months, okay, but he's leaving the company, right? Because of that, I'll be having a lot of losses. What kind of verbiage I need to include while releasing the offer letter? Because most of the employers just take some random template online and use it as the offer letter, right? So what kind of measures the employers have to take to protect themselves?
Yeah, so employers, so I wouldn't just rely just on an offer letter. I would also have a very airtight employment agreement, right? The offer letters are very short, right? They're a page long, maybe 2 pages. You can't fill a lot of legal language in there to protect yourself in that. So you're going to put a lot more clauses in there that'll give you protection in an employment agreement.
Right.
So we have a whole team dedicated just for these agreements that can draft them for you and get them sent out. So a lot of these clauses can include anything from preventing liquidated damages, which we talked about earlier. That's a great one because you don't have to specify this or that. You could just say, if there's a breach, we'll get this money automatically. And it's very easy to get. And we'll also have an attorney's fees provision where if you breach, not only will you have to pay the liquidated damages, but if you don't pay it on time and we have to use an attorney, all our attorney fees are also the employee's responsibility. So we put language like that to give some additional protections for the employer. And there's a lot of clauses, and each clause is going to be jurisdiction specific, unfortunately. So it depends where you are. We're going to tailor that employment agreement to your jurisdiction.
Understood. Let's say I opened up a company. I'm a brand new business owner. As we are talking this, I feel like having employment agreements in place and want to follow some protocols, whatever you mentioned. Okay, how expensive it will be for me to have a law office like you as a backup to generate employment offer letters or any kind of contracts between employer to vendor or employer to client. So how expensive it is?
So here's what I will say. It's cheaper than losing one employee.
Okay.
It's a lot cheaper than losing one employee. Employees are the biggest asset for any company, especially consulting firms, right? That's the only asset that they have.
Right.
So you spend time and money recruiting, training, and retaining those employees. Losing one of them is going to cost you a lot more. So, and the way we do it, we don't charge you every time we have to do this. Well, when you're a new company, we'll draft all the contracts you need. We'll give you templates so you can actually fill in the blanks as you get new employee every day. So you don't have to come back to us for every employee. If you need changes to it, certainly we can fine tune the contracts based on any specific individual. But generally, a lot of these companies that come to us, we create a package for them initially that includes MSAs, SOWs, employment agreements, offer letters, and a whole host of other agreements. And you'll have it in your library when you have a new employee come in, you just fill in the blank and kind of submit it. Unless you do specific changes for, you're going in a different tier of employee or something like that. You started off with a consultant, now you're going C-level or something like that, then we can change that up for you.
Perfect. Thank you.
Yeah.
And I have one more question. Probably we can jump on to tenant and landlord issues.
Sure.
The last question is, nowadays, many employees are working over 40 hours a week, okay, on different project. So what's happening is employers are getting contract from another vendor or another client, but utilizing the same workforce on different project. because he's not running the payroll on them, but the contract is between between the employer to another vendor. Okay,
Sure.
he's supposed to pay that money to the employee either in the form of overtime or anything. Okay, so here there is no proper documentation. Employees are losing that kind of money from employers who are not willing to pay. Probably, let's say the employee worked for the period of 1 year, they're paying up to 6 months, and they're not paying for the 6 months. And these people not having the proper documentation with the new project or new client. How can they fight in these kind of cases?
Yeah.
I don't want to call it as second job. In many people are doing that, but
Yeah.
what kind of protection these people can have?
Well, so there's multiple tiers to your question. So let's kind of dissect that. First off, there may be immigration implications both for the employer and employee. So Santosh, my partner, is the foremost expert in that. So he'd be able to advise you on the immigration aspect of it. We'll talk strictly litigation. From a litigation perspective, couple of things to keep in mind, right? Remember what I said earlier, document. So document this as well. So if you have an employment agreement with your company, let's say your company's name, your employer's name is ABC LLC, right? ABC LLC's end client is a big pharmaceutical company, right? That's who you've been contracted to work for. And your employment agreement says Vijay Yellareddigari has to work for ABC LLC at end client's location in New Jersey at Pharma LLC, right? And that's what it says. Now, if you don't have an employment agreement very specific like that, that's where you get into trouble. Now, in that scenario, you work 40 hours for Pharma LLC. Now, your employer is also asking you to work for Defense Contractor LLC for another 20 hours or 30 hours on the side, right? There's no agreement here.
There's no agreement.
So when that happens, if your original employment agreement is very clear saying ABC LLC hires you specifically to work at Pharma LLC, you're covered because now you're working somewhere else other than that. So you can then go after them for the additional wages because it's a whole different task that they've assigned you to. But if your employment agreement isn't clear or specific, then if they just say we're hiring you as a salaried employee, ABC Tech is hiring Vijay Yellareddigari as a salaried employee for 100K, and that's it, they can place you anywhere they want, and especially if you're an exempt employee, right? And most of our viewers here probably are exempt employees where they're highly skilled, high-level positions. They don't get overtime. So whether you work 40 hours or 80 hours, not going to make a difference from Department of Labor, right? You're getting your salary.
Right.
So if you have this very clear language in your employment agreement, you'll be protected because you could say, I did my job for Pharma LLC, but now you're asking me to work for Defense Contractor LLC. I'm not going to be able to do that unless you pay. And again, if they ask you to do that, get a separate employment agreement for that. So you're covered.
Got it. Now,
assuming all the immigration issues have been addressed.
Right. So it all comes to the offer letter again. If you compromise for the simple offer letter, like mentioning that you're working for ABC, that's it. You cannot go after them.
I'm not saying you can't go after them. It becomes harder.
It becomes harder.
Because what proof do we have that their job didn't include doing both of these?
Understood.
Right.
Understood. Perfect. I think this is valuable to many people here. And any other scenarios that I'm missing here?
You know, I can go on for hours just talking about employment law. So if you think of anything specific, I'll be happy to go into more details. Yeah.
Okay. I have the other one. Sometimes employers do not pay employees, but they try to keep the communication in the phone calls instead of emails or text messages. And while in the phone calls, they kind of literally tell them that I'm going to kill you, or I'm going to do this, I'm going to do that. Can the employee take any action based upon that on the employer? If he have call recording or anything, any proof that he can produce?
So a couple of things to keep in mind with those scenarios. One, if you're recording a call, be aware where you're located, where they're located, and look up the jurisdictions. Is it a single party notice state or a dual party notice state? And you could Google that, you'll find that information very easily. What that means is some jurisdictions, both parties have to consent to that recording for that to be admissible in court. In some jurisdictions, it's single party. So you're recording and you consent to that recording. It doesn't matter if they consent or not, you'll be able to admit that into court. Just because you have recording, you can have all the evidence in this world. Unfortunately, when we go to trial, some evidence might not be admissible. What that means is the judge or the jury won't even listen to it or look at it. So we can't even use it. Even if they confess to everything on recording, if it's not admissible, it means absolutely nothing for us.
Understood.
So we got to be careful about that. But second issue, which is probably the bigger issue here, is if you're getting threatening calls and you feel that there's imminent harm to you, call the police, get a police report done immediately. That will be helpful because if your call recording is not admissible, the police report would be admissible.
Okay.
That you called immediately after this call and testify or gave a report to the police, and the police officer or the report would be admissible to testify against that individual that made the threatening remark.
Okay, but what if an employee is willingly creating a scene like he's threatening him?
The employer threatening the employee?
Yeah, it's not real, but he's trying to create something like employer is threatening him on the phone call and he called the cops.
It can happen.
Yeah.
But the thing is, it's going to come down to evidence, right? What proof does he have to support that?
Right.
And then for example, usually assault is the charge that we would bring on for that, unless, it depends on the jurisdiction and they're doing a criminal charge, terroristic threats and all that stuff. But assault is what we do on the civil side. If I'm filing an assault, it has to be imminent harm. If I'm sitting in California and saying, I'm going to come and beat you up in New Jersey, is that imminent harm? Not really, right? No. But if I'm in the same state and I threaten to come and harm you, yeah, that's going to be. I've had scenarios, exact fact pattern, which you mentioned, where I represent the employee and the employer said, you know what, I have people back home. I know your parents back home. I'm going to take care of them. Right? And they even had people go and visit the parents' house. Courts here can't do much about it because is it imminent harm? Can you prove that this individual is what caused that imminent harm? It's actually a third party that's doing it. So unfortunately, the law isn't going to reach over jurisdictions and protect you. So you just want to cover yourself and document.
Okay. So definitely employer and employee should always maintain that respectful relationship to avoid all this mess.
Yeah. Okay. And remember the original question you had, what if the employee just creates a scene to make it seem like the employer is doing that? Filing that police report is a crime if it's not true. And if the employer can prove evidence to the police that he fraudulently filed it, the employee goes to jail.
Understood.
So,
understood.
Yeah.
Awesome. Thank you. Thank you. Vijay.
Sure.
Now let's go to the real estate part.
Sure.
And thank you. But both the topics were super good, super informative. I believe a lot of our viewers might learn a lot of new stuff that we spoke. And many landlords and renters have this issue.
Yes.
We always trying to discuss from the employee or person who involved in an accident or from the renter. Let's talk from the landlord side.
Sure.
I rented my apartment to a tenant who is a bad tenant who completely damaged my property. Okay, but I have the holding of only 1 month rent as in advance, but it's gonna cost me at least $10,000.
Yes.
How can I collect that money? And what
Sure.
kind of documentation I should have ahead to collect that money?
So I'm going to give you a general opinion here because each state is very specific about this, how you handle this.
Right.
Generally speaking, follow the rules of the state to the T. That's very important on the landlord side. Majority of the states are landlord friendly. I mean, tenant friendly, not landlord friendly. So, one, you want to make sure if, for example, I'll give you New Jersey as an example since I do a lot of litigation here in New Jersey. In New Jersey, month and a half is what the landlord can collect. Wow. So go to the maximum month and a half.
Okay.
Before you even sign the lease, when you're shopping around for tenants, right? Do a background check. There's a lot of third-party companies out there available where you just submit the information online. Like Western Union, for example, is one. TransUnion is another one. I think even Zillow has their own background search service where the tenant creates a portal, logs in with their social security number, and then you get a report that shows what history they have as far as tenancy history, if they have bad history with landlords, credit scores. It doesn't give you the exact score. It says in the green, red, or yellow, so you know they're safe or not. And find out what they do for employment. You want to make sure they have enough money if they damage your property in excess of that security deposit, right?
Right.
A month and a half or a month or whatever the situation may be. So plan for that. I also, in all the leases that I draft, I always put landlord's ability to visit the property with advance notice.
With advance notice.
This way, landlord can once in a while stop in and say, and stop in with notice, obviously, give him a week's notice saying, I'm coming back. You'll at least see how the property's been kept in to the condition. If you've had issues before the tenant vacated, you can start the process then. After the tenant vacates, it's going to be hard to chase after them because they may move to a different state, they may move out of the country, there may be different scenarios. So when they're there itself, if you know that there's damage to the property, you start that process.
Understood.
And to finally answer, I kind of went around in circles, but to answer your question, what do I do? How do I collect? First, you got immediately as soon as they vacate the premises, document it through videos, pictures, whatever. In the perfect world, I tell all my landlords when the tenant is leaving, first off, when they sign the lease, I include a property condition report with the lease.
Okay.
The tenant fills out the condition the property's in. If they notice anything wrong, they'll fill it out. Landlord and tenant initial that.
Understood.
So you have a list of things, you know what's damaged ahead of time. When they move out, you ideally, when the tenant is literally handing you the key, walk around the property with the tenant, identify the problems, take pictures or video of those damages. And that way tenant can acknowledge potentially on that video saying, yes, that's wrong, yes, that's broken or whatever. Then immediately after that, have a contractor come out and give you an estimate for all the damage, a licensed contractor. So you have that itemized list, send that itemized list immediately to the tenant saying, these are the damages, I need you to pay for it. In some jurisdictions, by law, you're required to do that along with the security deposit notice. If you don't, you actually owe the entire security deposit back plus double that amount.
Understood.
In some jurisdictions. So it's best to do that within 7 days after they move out.
Okay.
Send that out. If they don't pay, then you can hire an attorney. We'll file a complaint against them in court, and then we'll be able to place a lien against them if they have assets.
Understood. Understood. And again, let's say all I have to collect is $10,000, and I have $2,500 in advance. Okay. For that $7,500, is it worth hiring an attorney and going after them?
It depends on the jurisdiction. Again, in my leases, I always say if I have to enforce any of their lease terms, attorney's fees are covered by the tenant.
Covered by the tenant.
If that's in there, then yeah, why not? They're going to pay for the attorney's fees.
Perfect.
In some jurisdictions, $7,500 is small claims court.
Okay.
It's very simple, small claims court. You can do it yourself.
Okay.
And usually a lot of the courts have step-by-step process on what you need to fill out, what form you need to submit and all that, and what you do in court.
Okay.
And if you ever run into a scenario where you're not sure, reach out to an attorney in that local jurisdiction. We'd be happy. I've had many times clients reached out to me. They're my existing clients. They're like, I don't feel like paying for an attorney. It's only $4,000. It doesn't make sense. I'll usually tell them step-by-step what to do, and they'll just take care of it themselves. So a good attorney should be able to advise you on that.
Perfect. And at the same time, just like we spoke about employment agreements, people use templates. Even for renter agreements, landlords use templates.
Yes.
So what do you suggest here?
Don't use templates because those templates are a cookie cutter, right? One size does not fit all. Everyone has their own specific concerns and considerations, and you want to. And sometimes I've seen this happen more often than not. They go online, they find a lease, they sign it. In New Jersey, that lease may not be valid. There may be some terms in there. So if any terms in the lease are against certain aspects of the lease, if the tenant decides to actually sue the landlord may end up having to pay the full lease amount back to the tenant plus double penalty. So double the amount back. So it's not worth it. couple $100 to get a lease drafted specifically for you is well worth the, and you probably have to do it once, right? And if you have
Okay.
tenants after that, you could probably use the same format. Maybe you can ask the attorney who drafted it,
Mhm.
hey, are there any updates in the law? We'll just make some updates. It shouldn't cost you much.
Understood.
We spend more money on stupid things, going getting Starbucks. You could probably, if you cut back on a couple of Starbucks drinks, you could probably have your tenancy covered.
Understood.
So you'll be protected
Yeah.
a lot better.
So while recovering that money, the landlord should pay the attorney fees if that is not previously mentioned in the lease document, right?
I need to understand that. I'm sorry.
Let's say I have to collect the money from my tenant, but if I do not have those terms in my initial lease, so the landlord have to cover the expenses by themselves. If
That
they
is correct.
have the proper verbiage, they can collect from the tenant.
That is correct. Yeah,
Okay,
that is correct.
perfect. I think we have only 2 minutes. I think it will auto shut down. Before we shut down, I have one more question. Many people have this. Sometimes property owners rent some bad apartments. They have a lot of bugs, roaches. How many times you complain? They do not take proper action, and sometimes you will be having some bad neighbor who always kinds of disturbs you. Sometimes a bad neighbor always complain on you because he don't like you. He intentionally complain that this guy is creating some disturbance. In those cases, these property managers, what they ask is like eviction, issue a eviction notice. Hey, please leave. And then after they leave, they send them some $4,000 or $5,000, just like you broke your lease. So what is the chances for them? How do they come back?
So you're talking about from the tenant's perspective?
Tenant's perspective.
Yeah. So you have in most jurisdictions a right to quiet enjoyment.
Mm-hmm.
So having bugs and roaches and bad neighbors and all that are violating that right to your covenant to quiet enjoyment. So you can actually file a notice with the court if your landlord doesn't let you off the lease.
Okay.
And the court will let you off the lease. You usually put the money aside in an escrow account
Mm-hmm.
and not give the money to the landlord. Sometimes we're like, oh, I won't give you the money until you fix it.
Mm-hmm.
You can't do that. Put it in a
Okay.
separate escrow account.
Separate escrow
And when you go to a judge will be like, did you put money in the escrow? That's the first question they'll ask. If you say no, you lose the case.
Understood.
If you say yes, then the judge can end that lease as of that day. You can walk away so you don't get any penalties from your landlord afterwards.
Understood. If owner said just vacate my place, do he still have right to ask money to the tenant?
That would potentially be considered eviction. And you can actually have claims against the owner. Depends on the reasons and circumstances.
Understood.
And you can actually charge the owner for the new lease that you have to sign. And if the value of that lease is higher than what your lease presently is, that difference for a year is what the landlord has to pay you.
Landlord has to pay you. Just in case, many people think that affording attorney might be super expensive. Okay, they're asking some $3,000 or $4,000. I will pay. How friendly attorneys in terms of managing these kind of small cases, in terms of directing them or consulting them? Can you give a small brief?
We are a full service firm, so if you want to reach out to us, we can certainly help you with that. And if it's something we can't, we'll connect you with the right attorneys. Most good attorneys aren't just there to make money. They're there for a passion. If they're doing landlord tenant, they love doing that work, so they want to help people. So most, some bad attorneys give a bad reputation for all. We're not there just to make money. I got into the field because I want to help. So if it's something I can't do, plenty of times I've recommended other attorneys who can, and they usually work with them on pricing or whatever they can. And I can even call and talk to them. Sometimes I've done that to another attorney saying, hey, this person really needs help them out with the fees and stuff. And within attorneys, we help each other out, and they help in turn the end client.
Understand. So the tenant is protected if he got an eviction notice.
Yeah.
He don't need to really pay that money.
Potentially. Again, depends on the jurisdiction. There's a lot of protections for tenants under landlord tenant law in most jurisdictions. New Jersey, for example, has a lot of protections. There's some states, Pennsylvania, neighboring state, not as many. So like in New Jersey, if that happens, you get all the money, all your attorney's fees. If you hire an attorney, no matter how much it costs, all that is covered. Pennsylvania, you just get reimbursed for any expenses out of pocket, no attorney's fees covered and things like that.
Perfect. I think this is super valuable for many people.
Yes.
Because most people in this community are students, and they always feel like I might not able to fight with my landlord. And sometimes landlord try to scare them by sending some legal notices.
Yeah.
So while receiving these legal notices, do these tenants really need to respond to them?
Yes.
Okay.
It's best to respond, because if you don't respond, they may file in court and it
Mhm.
becomes more expensive then, right? So it's best to respond
Mhm.
just to find out what they're looking for. If it's something crazy
Mhm.
out of this world,
Mhm.
then let them file in court and then defend that claim.
Understood.
A lot of times, landlord tenant court does not require an attorney.
Mhm.
Usually, landlords will have an attorney. It's a good idea as a tenant to have an attorney as well, but
Okay.
it can be done without an attorney as well from the tenant's perspective.
Without an attorney also. Okay.
Yeah.
Seems like Instagram restored the previous feature. It did not ended after 1 hour. I think we can
Sure.
talk. I'll ask a
Yeah.
couple more questions
Sure.
and we can end this.
Yeah.
And let's say I have a dispute with my neighbor.
Yes.
It can be because he laid a fence in my property line, or else he's causing some nuisance, uh, or anything, any dispute with my neighbor.
Yeah.
What is the best way to handle it?
That becomes very tricky, right? Because you're going to have to live with this person
Yeah.
in the future.
Right.
I always say when it's neighbor disputes,
Mhm.
try to talk to the neighbor, try to resolve it peacefully, amicably.
Right.
If it doesn't, then get an attorney involved. And even when we get an attorney involved, I've done a couple of neighbor dispute issues.
Mhm.
The way I like to do it is I actually like to call the neighbor and just have a conversation, have them come into my office, talk to them before I send legal notices or anything formal. Because as soon as you send legal notices, it becomes adversarial, right? We try to fight each other, which is not what I want, because my client ultimately has to live with that neighbor next to them. So try to resolve it. Sometimes you have to give and take, because you may be 100% right, but remember, it's your neighbor. You may win in court, but that person's going to make your life living
I know. In a
in a
hell.
nightmare. Yeah.
I got it. I got it. So while we are here, I would like to go back to one of our previous topics, which I got in my mind. I forgot that.
It's okay.
While you're
It
talking,
might come back as we talk about something else.
yeah. Okay. It's regarding employment. Let's say I'm working for an organization. My manager is intentionally targeting me, in the form of not giving promotions, or else not giving pay raise compared to other employees. What is the best way to fight for this? Are there any laws that an employee can go against an employer for not being fair with him?
There certainly are. There could be discrimination laws,
Mhm.
right? There could be harassment laws if the employer is continuously doing this to them. The best way to go about doing this is document your case. Again, I go back to that same word over and over.
Yeah.
I hope the listeners get this and viewers get this.
Right.
Document. So
Document.
all your employment records, right? Keep track of all of those. Keep track of all your performance evaluations. If you can show that you've had numerous positive performance evaluations, but every other person is getting promoted, every other person is getting pay raises, then you certainly have a case. Now it's going to come down to, is it discrimination, is it other area of law? Would have to then, that's why contact a lawyer, document and then contact a lawyer. We'll have to determine based on your jurisdiction what it might be. And even though there's certain discriminatory protections, they may not be applicable to you based on the size of your employer.
Okay.
Certain laws only apply if the employer has 50 or more employees in that jurisdiction or something like that. So we'll have to take a look at what your specific scenario is, and then based on that, there could be a claim. And more than likely there is.
Understand. Let's say even in the annual evaluation, employer is taking recommended, precautionary measures in terms of giving you the average to below average rating, although you're performing well.
Yeah.
Okay. Can the and also employee can counter to those reviews. So what do you suggest in this case?
I would actually inquire why. So when the manager sits down and explains, "Hey, these are the reviews you're getting,"
Mm-hmm.
I would ask why
Mm-hmm.
you're getting those if they're below standard.
Okay.
Especially if your performance has been great and you have emails showing, you're doing all the tasks ahead of everyone, you're doing more than everyone else,
Mm-hmm.
and there's no issues, no one's complaining about your work.
Mm-hmm.
Find out why your evaluations are low and
Okay.
document it through email.
Okay.
Copy them, copy HR always
Sure.
on those
Mm-hmm.
communications.
Okay.
And then if that manager is not responsive,
Mm-hmm.
copy their superior as well on it
Okay.
to find out why this is happening.
Mm-hmm.
Because if you can document and they can give a actual reason, a bona fide reason
Mm-hmm.
of why that evaluation is lower,
Mm-hmm.
then they're protected. If they can't, then you're protected. You may have a case against them.
Understood.
Yeah.
Understood.
And there are times when employees do stellar work,
Mm-hmm.
but they get bad reviews,
Mm-hmm.
and it may be a bona fide reason because they're not doing the tasks they're assigned. They're doing other areas of work
Right.
10 times more than everyone else, but they're not doing the tasks that they're asked to do.
Thus they got
So that
assigned.
happens.
Okay. Understood. I have one last scenario, and that should be all.
Sure.
I heard this scenario that the employee have an issue with her HR manager. Okay, and during her OPT extension, employer should sign. So here in this case, that HR manager have to sign, and he is denying to sign. But they signed, they processed that to the other employees, but kind of resisting on him. How can he proceed further?
So the manager for this employee,
Mm-hmm.
did they confirm they want to hire and continue to have
Yes.
this employee work?
Yes, manager have no issue. Manager want her to continue, but the HR manager who had a dispute with this employee is kind of blocking it.
Okay.
In the real scenario, they made her wait until 45 to 60 days, literally tortured her mentally, and finally they signed on her document. But if someone faced this kind of scenario, how can they fight?
There potentially could be discrimination, right? If she performed equal to all of her peers and they are discriminating, especially if they have the position available. Now, if the position was not available, that's a different story.
Understood.
But if the position was available and they're doing this for X, Y, and Z reasons, then you potentially have a claim.
Understood.
If she pointed out something that's wrong and if she reported it to an authority, when I say authority, I mean federal or state level, she may have whistleblower protections as well.
Understood.
So it depends on the very specific facts of what that dispute was between the HR manager and her. That may come into play on whether she has a case or not.
Understood. Yeah. And again, documentation matters.
Exactly. Document. Yeah.
Perfect. Amazing session, Vijay. I know we covered only very specific topics, given that litigation is a vast subject that we can talk.
Yes.
So I would definitely bring you next time to talk on different other topics that we did not tap this time. Yes. And I really thank you for spending your time on a weekend. I know weekends are very precious for us with the family time. So I appreciate your time, Vijay. Thank you very much. We'll see you in the next session.
I appreciate having me. Thank you.
Yeah, thank you. Bye.